I want to welcome you all to our 6th annual Rosenkranz debate and express our gratitude to the Rosenkranz Foundation for supporting this event. We love having this a Saturday kind of centerpiece for our convention, which has been traditionally an intellectually sharp one-on-one debate between two highly prominent legal theorists. The series had a wonderful start in 2008 with a discussion between Judge Richard Posner and Mike McConnell. In 2009, the debate featured Judges Guido Calabresi and Frank Easterbrook. In 2010, it featured Professors Richard Epstein and William Eskridge. In 2011, Paul Clement and Larry Tribe debated healthcare. Last year, Judge Kaczynski and Professor Hadley Arkes debated. To moderate this year's debate, I want to introduce Judge Jerry Smith of the U.S. Court of Appeals for the Fifth Circuit. Judge? Judge Smith was appointed to the court in 1987. Before that, among other things, he had served as city attorney of Houston and as a partner at Fulbright and Jaworski. And in closing, I'll mention, back when he was at Yale Law School, he'd been my freshman counselor when I was in college. Jerry?
We have a spectacular debate today, and the topic, as you know, is resolved that courts are too deferential to the legislature. Today, we examine only the affirmative and negative sides of that resolution with full recognition that at any Federalist Society discussion, there are always other alternative perspectives on the topic at hand, but today we examine only the affirmative and negative sides of the resolution. Now, in putting together today's debate format, we wrestled a little bit with the physical layout here on stage. One possibility was to have two podiums, but that would seem too much like a presidential debate, and nobody wants that. A second possibility was to have one podium, but that would maybe get a little crowded. A third possibility, given the likelihood of a major clash between these two spectacular debaters, would be to have a boxing ring, but we decided there wasn't quite enough room for that. But then, in light of the success of the Thursday night format, by the way, was that the best Federalist Society banquet ever? Was that spectacular? With Justice Thomas and Judge Sykes, that went so well that we decided that the chair format was probably the best, and so that's what we're using here today. As I said, we have a spectacular set of combatants to present the two sides of the resolution. Randy Barnett is the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center, where he directs the Georgetown Center for the Constitution. After graduating from Northwestern University and Harvard Law School, he tried many felony cases as a prosecutor in the Cook County State's Attorney's Office in Chicago. A recipient of the Guggenheim Fellowship in Constitutional Studies, Professor Barnett has publications that include 11 books, including case books on constitutional law and contracts, and more than 100 articles and reviews, as well as numerous op-eds. A new expanded edition of his book, Restoring the Lost Constitution, The Presumption of Liberty, was just published by the Princeton University Press. In 2004, Professor Barnett argued the medical marijuana case of Gonzalez versus Reich before the Supreme Court. In 2012, he was one of the lawyers representing the National Federation of Independent Business in its constitutional challenge to the Affordable Care Act. So we look forward to hearing from Professor Barnett. Judge J. Harvey Wilkinson III serves on the United States Court of Appeals for the Fourth Circuit. He was appointed to that court by President Ronald Reagan in 1984 and served as its chief judge from 1996 to 2003. His most recent book is Cosmic Constitutional Theory. The book laments the fact that the leading theories of constitutional law have resulted in the decline of democratic self-governance and the loss of the great tradition of judicial restraint. Now, I do have to add a little personal note, which was that I was privileged to know Jay Wilkinson when we were both undergraduates at Yale. There were some differences. I was a right-wing activist, and he was, well, if you'll pardon the expression, an establishment Republican. So Jay and I knew each other well enough in those bright and tender years that we have a mutual agreement not to tell any embarrassing old stories on each other, although, Jay, I suppose probably under Connecticut law, the statute of limitations is run on most of those. Of all the people I know, Jay is the most thoroughly and wholesomely and quintessentially a gentleman of Virginia, which I consider as a real and thorough compliment. We'll now begin the debate, and Professor Barnett will take the lead. Resolved that courts are too deferential to the legislature.
Well, thank you very much, Judge Smith. And by the way, I didn't realize that you two had this opposing role when you were in college. I see not that much has changed since that. Well, anyway, I'm very happy to be here. I'm very honored to be here. I've attended these debates for many years now. It's a huge event, and it's a different configuration of this room, as those of you know have been here before, but there are certainly a sea of you out there. It's a very important topic, and I'm going to hope to give it some do it justice. In my opening remarks, there's basically three topics I want to address. The first is the idea of popular sovereignty and why popular sovereignty gives rise to the need for a written constitution. The second is going to be about the judicial duty to enforce that constitution by evaluating the constitutionality of statutes. And you'll notice I didn't say power, I said duty. I'll say more about that later. And finally, I'm going to end by talking about the problem of double deference, which is the way that deference actually plays out in the legal system and the political system that we live in. So first of all, let me talk about popular sovereignty and the reason for a written constitution. As you know, in other countries, let's say Great Britain, sovereignty is not considered to be in the people. Sovereignty is either in the king or the king in parliament or in parliament itself. But those are countries that we might say have parliamentary supremacy or parliamentary sovereignty. And this is not the kind of form of government that we have. In our country was founded on the premise of popular sovereignty. Now, I know I'm not saying anything here that all of you don't already know, but I think one of the things that maybe we do inadequately keep in mind is that this sovereignty includes each and every one of us. That is, the sovereignty of the people is not a sovereignty of the majority of the people. A majority of the people, James Madison considered to be a faction. That was a subset of the entire people, and sometimes a majority can act contrary to the general right, the rights of the general community, the rights of the minority, the rights of every person, and the general welfare of the community at large. In fact, what Madison said was it was the greatest danger in a Republican government lies in the majority of the people, not in the majority of the legislature. That was a very big danger, but in the majority of the people was where the greatest danger was. He said the greatest danger is where the greatest power is, and in a Republican form of government, that is in the majority of the people. It's in the people, and so a majority of the people pose the greatest danger, and there needs to be a constraint on that. Now, in case you think I'm being somewhat theoretical or hypothetical about this sovereignty residing in each and every one of you, I thought I would read the only two quotes I intend to read in this debate, and they are two quotes from opinions in the first great constitutional case that was decided by the first Supreme Court, and that was Chisholm versus Georgia. And the first quote is from James Wilson, a great thinker, a lecturer, the first professor of law at University of Pennsylvania Law School, and also one of the members of the Committee of Detail that provided the text of the Constitution. And Wilson referred to the laws he said laws that derive from the pure source of equality and justice must be founded on the consent of those whose obedience they require. The sovereign, when traced to this source, must be found in the man, meaning in the individual. The sovereign, when traced to this source, must be found in the man. And then John Jay, as you know, John Jay, one of the earlier authors of the Federalist Papers, ended up being the first Chief Justice. In his opinion, he actually uses the term popular sovereignty in his opinion, and he describes the people who are the sovereigns of this country as, quote, fellow citizens and joint sovereigns, meaning each and every person is part of the sovereignty of the country. So, therefore, where does government come in? Well, government is established in order to secure the rights of the people, and that is the rights of each and every person. And this is stated in the Declaration of Independence, as you know. First, there's the famous sentence about the natural rights to life, liberty, and the pursuit of happiness, which is followed by the other sentence, that is, it is to secure these rights. It is to secure these rights that governments are institute among men. These are the rights of the sovereign people. Now, how do you do that? How is it that you can secure the rights of the sovereign people against those who form the government, who can at best only be thought of as the agents of the people, or as we used to think, the servants of the people? You sometimes hear this public servant idea. You may have heard it yourself at some point or another. They are supposed to be our servants. They don't act much like servants, I must say. But that is the general theory. It's sort of an archaic idea. They are our agents. They are our servants. Well, how does a master or a principal handle or control the behavior of their servants? Well, there's a lot of ways you can do it, but in our country, given the fact that we have popular sovereignty, we did it by means of a written constitution. A written constitution is the law that governs those who govern us. It's the law that governs those who are supposed to rule as our agents, which means on our behalf and subject to our control, which is the definition of an agency relationship. And so the way we do this is to issue this rule book to them, and they say they must follow it. And that's each and every agency, each and every department of the government must do so. The Congress must do so, and the President must do so, and the judiciary must do so. In fact, the judiciary are agents of the people. We hear a lot about how the Congress or the legislatures are the agents of the people. In fact, the judiciary is the agents of the people. They are tasked with a job on behalf of the people, and that is to ensure that the principles that are conveyed in this book are used to secure the rights of the people, as the Declaration, the rights that are retained by the people, as the Declaration of Independence refers. Okay, so what does this entail for the role of judges? This comes out to the role of judges. And what it entails for the role of judges is that judges must follow the law. They have a duty to follow the law, and they have the duty to follow the higher law as opposed to the lower law, and the higher law is the law provided by the Constitution. A lower law would be a statute. Now, you notice I haven't said anything about the power of judicial review. I've just talked about the judge's duty to follow the law. Philip Hamburger, who spoke this morning, I don't know if Philip is here. Philip, are you here? Well, he was here this morning. Philip Hamburger wrote a wonderful book about this topic. I don't agree with every single thing that's in that book, but the core of the book I do agree with, and I think it's very important. And he argued that the whole idea of the power of judicial review is anachronistic. The founding generation didn't speak of the power of judicial review. Some draw the inference from that, then therefore the judges aren't supposed to do anything. That's not true. What Hamilton says in Federalist 78 is that in fact, the Constitution is the higher law, and there's a duty of the judiciary to follow the higher law as opposed to the lower law when there's a conflict. And in fact, that's all John Marshall says in Marbury versus Madison. He never talks about the power of judicial review. The power of judicial review is a concept that develops in the 20th century. And notice what the difference is when you shift from duties to power, what happens. A power is something many of us have, all of us have, and a power should be exercised with discretion. A power should be exercised with restraint. So by identifying this power of the judiciary as a power rather than as a duty, now you introduce the idea of limiting that power, which was the whole idea for why the progressives started talking about the power of judicial review rather than this duty. We don't talk about duties that way. We don't say that there's a duty, but you must exercise your duties with restraint, or you must exercise your duties with discretion. If you have a duty to your children, you have to simply do your duty. That's what you have to do. So that was a very important shift. Okay, so I think I'm looking at the time here. I want to make sure I get in here. So let me I can talk a little bit about the practicalities of how judges should go about doing this duty. I do not agree that this involves the identification of particular rights and elevating these rights to some elevated status, which is in fact a post-New Deal way of doing this, in which some enumerated rights get privileged, and then we add some unenumerated rights to those lifter rights that get privileged, and they get special protection. I believe in protecting liberty across the board, the way it had been protected up until the 1955 case of Williamson v. Optical, which is a Warren Court case, I should say. And prior to that, and that's the invention of the rational basis test that we currently think of as gospel. Rational basis is just the evil twin of substantive due process, preferred liberties. Preferred liberties get heightened scrutiny. Everybody else gets basically no scrutiny. All other liberties get no scrutiny. That's a completely modern post-New Deal doctrine that was originated in Williamson v. Optical. And if you want to see what judicial scrutiny really looks like, what judicial engagement really looks like, you should not read the Supreme Court's opinion in Williamson. You should read the lower court's opinion in Williamson, in which a three-judge panel found quite accurately that the law in Oklahoma was basically intended to privilege the rights of ophthalmologists and optometrists at the expense of opticians, but in particular at the expense of an out-of-state company called the Lee Optical Company that was basically doing business like lens crafters. And the ophthalmologists didn't like that, and they got their buddies in the legislature to pass a law against it, and the lower court found that this was not an actual health and safety measure, and even though they had adopted a presumption of constitutionality, they found that it was unconstitutional. So this is something that is within the competence of judges to do, and it's something that is their duty to do. That is, the old standard was that if a law was irrational, arbitrary, or discriminatory, then it was an unconstitutional exercise of an enumerated power, and therefore would be improper under the necessary and proper clause, or it was an unconstitutional exercise of the police power because the police power did not extend to passing laws that were irrational, arbitrary, or discriminatory. Finally, let me talk about the problem of double deference, because in practice, deference to legislatures sounds okay, and in principle, I myself don't have a problem with what is sometimes referred to as deferring to the policy judgments of legislatures. I think that's entirely okay. Legislatures do engage in policy. The judges generally should not engage. They should not engage in policy. Strike the generally. They should not engage in policy. That's not their job. Their job is to assess constitutionality. It's not to choose wise policy over bad policies. That's not their job. But in practice, what deference to the legislature then is switched to mean is deference to the legislative assessment that a law is within its powers. That is, deference to the legislature's judgment that a law is constitutional. Now, that's not something I think judges should defer to. They are an equal branch of the federal government, and they're entitled to their own opinion about whether a law is constitutional, and there's no reason why the legislature should get two bites at the apple and have exclusive control over the scope of its own powers. That would be to not respect the rights retained by the people. But what really happens in this town, everywhere, when this happens, and this is, and I would defy anyone to say that this isn't what happens, and that is when a judge, when the federal courts or when the Supreme Court defers to Congress and says, no, we defer to you and your judgment of constitutionality, what happens when you go across the street and on the Hill and ask a legislator whether what they're doing is constitutional? What answer do you get? The answer that you get every single time is, what I'm doing is constitutional because the courts will uphold me. What we're doing is constitutional because the courts will uphold me. Well, if the doctrine is that the courts will uphold you because they are deferring to your judgment of constitutionality, and then you say a measure is constitutional because the courts will uphold me, then this is what's going on, and this is what's being lost in the process. You have each side pointing the finger at the other side. That's not my job to say whether it's constitutional, that's their job, and each side does that. This completely drops from the process, and as a result of the doctrine of double deference, we end up having lost very important clauses of the written Constitution that is meant to secure the liberties of the people, the sovereign people, each and every one of us. Thank you.
So as we say on the court, your time has expired and you've saved time for rebuttal.
Thank you.
Judge Wilkinson.
I want to say, first of all, what a great pleasure it is to be here with my friend Randy Barnett. He is one terrific person, and he's a very influential scholar, and I hope you'll spend some time reading him and grappling with his ideas, because I sure have learned a lot from doing so. Now, last time Randy and I, whether he's a good dinner companion is another question altogether. last time Randy and I were having dinner, he attacked me so relentlessly, I never got a chance to finish my smoked trout. If that doesn't tell you how out of touch judges are, I don't know what will. We're in a pretty elite crowd here. Now, you know, I'm for the restoration of the rule of law, and Randy's for government by judicial fiat. And other than that, we see eye to eye. This rule of law, it's our sacred birthright, and what we did was we exchanged bayonets for words. That's what we did. Words are our masters. And when I see Randy and his good friends take the Ninth Amendment and the Substantive Due Process Clause and the Privileges or Immunities Clause, they pick out the very vaguest phrases in the Constitution, and phrases in which the judges can pour whatever meaning they want to into. These are the most elastic vessels one can imagine. And William J. Brennan would be proud. You can't just do whatever you want with these things. You've got to have, if words are our masters, we can't take the most vacuous provisions of the Constitution and say we're going to do whatever we please. And that was the problem with the case that gave rise to what's colloquially called the conservative movement, is Roe v. Wade. Because it wasn't just that you were pro-choice or pro-life or whatever that explained your reservations about the decisions. The difficulty was that it was nowhere in the Constitution. The framers didn't think about it. The Constitution doesn't mention it. It's a vast constitutional silence. And when judges decided to read their views into the Constitution, they forsook the basic tie between law and words. They severed law from words. We're at a very difficult state of affairs, my friend, both with liberals and conservatives. Liberals are pursuing a philosophy of unenumerated personal rights, personal autonomy rights, lifestyle rights. Conservatives seem to want to mimic them in some respects. It's a different set of rights, to be sure, but these are economic and economic autonomy, market freedoms, a right to earn a living, a right to contract. And so you have both liberals and conservatives today saying to the law, you can't touch me. You can't touch me. Well, let's examine that for a moment. Because lost in all of this dialogue is the concept of community. Look at the chair you're sitting on and the table that you're sitting on. Did you make them? No, somebody else made them. Somebody else produced them. What about the food that you just ate? Did you grow it? Did you get it to market? Did you prepare it? No, somebody else did that. And how about the clothes that you're wearing? Did you manufacture those? No. How'd you get here? You took a plane. Somebody else built the plane. All I'm saying is we don't live in a vacuum. We're dependent upon other people in countless other ways. And when we realize this debt to others, you begin to understand that our Constitution protects two forms of liberty. Individual liberty, to be sure, but also democratic liberty. Because democratic liberty preserves self-governance, and it preserves this concept of community that I'm talking about, and the right of communities to determine their own destiny, and a right which judges should not casually supplant. It's community, family, church, school, volunteer work, government that provides a springboard for individual self-realization. Individual rights and community self-governance shouldn't be at each other's throats, and yet the current constitutional dialogue suggests that they are. But individual rights and community rights are self-reinforcing. And judges need to respect the fruits of the democratic process, which are the respect of a community. Do I sympathize with those who want smaller government? You bet I do. You bet I do. But folks, the judiciary is a part of government. And when you want to hand power to judges, you are growing government. You are not necessarily maximizing freedom. You are enlarging government. Let's look at some of the most basic documents of American history. Randy's Constitution, I hope it won't read, "We the judges of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, do ordain and establish this Constitution for the United States of America." And is this Randy's Ninth Amendment? The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the judges. And here's my friend Randy delivering the closing lines of the Gettysburg Address. "We here highly resolve that these dead shall not have died in vain, that this nation under God shall have a new birth of freedom, and the government of the judges, by the judges, for the judges, shall not perish from the earth." Now, folks, let's understand the constitutional structure. Let's understand the basic design of our basic document. We got Article 1, which Article 3 follows Article 1 and Article 2. We can count. Article 3 is shorter than Article 1 and Article 2. But the basic difference is that Article 1 and Article 2 to a less extent contain basic lists of enumerated rights, and they are quite substantial. Now, if you look at Article 1, Section 8, you're going to find a long, almost endless list of congressional powers. Now look at Article 3. Are there any enumerated rights in Article 3 for the judiciary? There must be some. Randy, will you look under that table and see if you can find the enumerated rights of the federal courts? Maybe they're over in that far corner of the room. Will somebody look there and see if they can find some Article 3 enumerated rights? They got to be somewhere. The danger, I think, in handing power to the judges is that we're reducing ourselves to cheering or booing from the sidelines. You can't expect the judges to do your work for you. You've got to roll up your sleeves and do the work through the political process. You can get a stagecoach and you can ride me straight out of Dodge for what I'm about to say. You can boo me and you can hiss me, okay? It's a freebie. But the Chief Justice's vote in the Affordable Care Act case was courageous and it was correct. What we should do is leave it to the political process to point out the flaws in statutes, to expose the flaws in statutes. And the political process in pointing out the flaws in legislative enactment seems to be doing its job just fine. There's a danger.
As they say, your yellow light is on, but not the red one yet.
All right. There's a danger here, and that is that we're going to become too dependent on courts to do the things we want to do. with respect to minimum wage, zoning laws, occupational licensing statutes. I know many folks want to overturn a variety of labor, environmental, social welfare legislation as a menace to liberty. All I can say is, as a practical matter, they're not remotely the votes to do these things on courts. It's not remotely the votes to do these things. And unless you succeed politically, the situation is going to become ever more grim. Is judicial restraint a form of unilateral disarmament? If we hold ourselves in check and the other side just goes crazy with activism, are we on the losing end of the stick? I don't think so. I think judicial restraint is a populist cry of really formidable proportions, returning government to the people. But it can only be politically salient if it's not hypocritical. You can't just blow hot and cold with judicial restraint. And so the choice really is ours. It's yours to make. If you practice restraint on some sort of regular basis from the bench and in your own beliefs, you're going to have a powerful weapon, and one that's grounded in text and in the rule of law. And it will see you through in the long run. On the other hand, if we blow hot and cold and we say, we do this because we want to, and we do this because we have the votes to do it, then we've left the rule of law. And what we've placed ourselves in is a regime of arbitrary power, one divorced from law and one divorced from words. And that's not law. That's bringing us back one step closer to the rule of the bayonet. Thank you.
Sounds like you have plenty to respond to.
A couple things. I have to say, though,
he's got a whole half page of notes.
I was a little surprised. I mean, I was trying to anticipate what Jay was going to say when he got here, and I've read his book, Cosmic Constitutional Theory, and I was getting all prepared. I think the last thing I expected of him was for him to make the argument that you didn't make that. But that was before I heard Judge Smith's introduction of Jay, so I realized he was an established Republican from those days. So apparently the you didn't make that argument was alive and well. So at any rate, let me take a couple of the points up that the judge made, and these are standard difficulties that are raised with the idea of judicial engagement. And first of all, let me just talk about the term judicial fiat, and that somehow there'll be rule by judges. I'm opposed to that. I mean, I'm against rule by judges. The position that I'm defending and I'm advocating does not propose rule by judges. I'm proposing that judges are able and willing, that judges be willing, and I believe they are also able to say no to the legislature. And saying no to the legislature, and then we'll have to say, well, when they should say no. But I think saying no to the legislature is not the same thing as ruling the people. That is saying no to some subset of the people who are designated to be our agents, and is saying no to them when they're trying to restrict the liberties of the people, but that's not the same thing as ruling the people. So let me just, the shorthand for this was suggested to me by an old friend of mine, Leonard Liggio, and that is this phrase, that judicial negation is not legislation. Judicial negation is not legislation. It is simply not the case that when an Article III judge, third on the list that the Constitution enumerates of 3 different branches, gets a chance to evaluate whether a law is constitutional or not and says, no, it's not constitutional, the judges aren't ruling us. The judges are protecting us from those other folks who purport to rule us, who do rule us, but they have to rule us within the powers that they have. And so that's very important to keep in mind. Judicial negation is not legislation, saying no is not legislation. And given that we do have 3 branches of government, if Congress were in its wisdom to think that it cannot pass a law because it thinks it's unconstitutional to do so, just stop and think about that for a second. Think if that has ever happened. Congress does not pass a law because it thinks that law is unconstitutional. It's outside its powers to pass. I mean, it may have happened at one time or another in our history, but I certainly can't think of a time in my lifetime where I think that's happened, except in the case of, say, First Amendment law. But there's an exception because that's when judges will actually be looking over their shoulders. So put those aside. Generally speaking, okay, Congress, if it thinks it's not constitutional, they don't have to pass it. Judges never get a say over that. Never gets to them because the Congress says it's unconstitutional. If Congress thinks it's unconstitutional, the president thinks it's unconstitutional, the president can veto it on the basis of it being unconstitutional. Presidents used to do that. They don't do that so much anymore, but they used to do that. We had a tradition of that. Only if those 2 branches think it's constitutional, if and only then does the 3rd branch of government even get a say on constitutional or unconstitutional. And they only get to say that something is really unconstitutional. That's the only power we're talking about. And then they say no. And under our theory of government, it essentially takes the concurrence of 3 branches of government before a law is considered constitutional. All 3 branches must concur that the law is constitutional. Now, what is sometimes said is that the framers rejected the idea of a council of revision, which would have injected, and judges were going to be able to serve on that council, which would have been another check on power, and therefore they didn't believe in this power of review. But the argument that they used at Philadelphia against having a council of revision is that it would be the judge's job to find that a law was unconstitutional. That was part of the judicial job to do that, and therefore you don't need a council of revision, and also judges should not be serving on any council you have. All right, so that's point number 1. Point number 2, Jay talks about the vague phrases in the Constitution, and he singles out the 9th Amendment, which he admirably read to you. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. He mentions the Privileges or Immunities Clause. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. These, he says, are vague. But what's the consequences of him saying they are vague? The consequences of him saying they are vague is that he won't enforce them. Now, here's a judge telling you that this part of the Constitution, put in the Constitution by what we are considered to be the sovereign people in order to control those who control us, they didn't speak specifically enough when they wrote those words. Those are too vague. They didn't meet some contemporary standard of specificity such that they are deserving of being implemented by our judiciary. I believe in respecting the Constitution, and I believe in respecting all of the Constitution, even the parts like the Income Tax Amendment, which I don't like. I think it should be followed until it's repealed. And I believe that's the same thing is true about the 9th Amendment and the Privileges or Immunities Clause of the 14th. But why were those clauses put in there in ways that Jay finds too vague to be enforced? The reason is because the generation that wrote this document believed that the rights and the liberties that would belong to the sovereign people could not be listed because they were too numerous to list. And it would be dangerous to even try to list them. Nevertheless, some people said, well, we want a list anyway, so they gave them a list that was going to be truncated necessarily, and they put the 9th Amendment as a savings clause, like a necessary and proper clause is supposed to be a savings clause for power, and they said there's all these other rights that are protected as well. All right, so I don't think judges should be able to pick and choose which parts of the Constitution meets their level of specificity before they're prepared to enforce it. Finally, I want to talk about the idea that to recognize the protection of these rights means you can't touch me, which is the phrase that Judge Wilkinson used, that you can't touch me. I don't think that's the way constitutional rights work. I don't think it's how they've ever worked. It's not the way the First Amendment works. The First Amendment protects the right of freedom of speech. We all agree. That's one of the rights that Jay will agree to be enforced. He doesn't like the Second Amendment being enforced by courts. He thinks Heller was a big mistake. And we disagree about that. But that's an enumerated right he doesn't want to see enforced because there's historical disagreement about what it supposedly meant. But he agrees that the First Amendment should be enforced. And yet the First Amendment doesn't mean you can't touch speech. Everybody understands that we require judicial implementation of that amendment by developing, for example, elaborate doctrines governing time, place, and manner of speech. Time, place, and manner regulations of speech are not in the Constitution, but they are a necessary means of implementing what is in the Constitution. Judges would not be doing their duty if they did not develop that doctrine, and they're not doing anything wrong when they do. They're fleshing out, they are putting into effect, they are implementing the words of the Constitution. There is absolutely no practical reason why they can't protect all our liberties the way they protect the liberty of freedom of speech, one of the few natural rights that got included in the Constitution. Jay ended his talk by talking about arbitrary power. And arbitrary power is exactly what I'm concerned about. And it's exactly what the judges are there to protect us against. And it is the arbitrary power exercised by legislatures. That is the arbitrary power that we need judicial power, we need a judiciary to protect us against. And that was, in fact, the historic standard by which legislation was held to, whether a law was irrational, arbitrary, or discriminatory. And there are readily available ways to determine this because those very same techniques are used to protect our speech rights, our rights of assembly, and other rights that we have. Judges know how to do this, and essentially what it means is the legislature has to articulate the reason why they're doing it. There has to be some degree of fit between what they say they're doing and what they're really doing, and then judges are there to assess whether in fact this is a pretext for rent-seeking legislation, just the way that the founders experienced rent-seeking at the state level when states who were operated under the theory of democratic liberty passed debtors' relief laws and erected trade barriers between the states. And we made a written constitution with a different theory of republicanism in order to address that problem of arbitrary power by a majority. Thanks.
Judge Wilkinson.
Professor Barnett says I'm afraid to say no, that I just can't bring myself to say no to the legislature, that I'm just going to let the legislature sort of run riot and trample all our liberties underground. Well, that's just wrong. I'll say no when the Constitution says no. And the Constitution has a set of negative prohibitions that give judges a very specific textual mandate to say no. And we know what they are. They're the First Amendment, do not abridge freedom of speech. Do not abridge the free exercise of religion. Do not establish a religion. Do not undertake unreasonable searches and seizures. Do not deprive someone of their right not to incriminate themselves. Do not deprive them of a right to lawyer, or the right to a cross-examination. Do not discriminate on the basis of race. Where the Constitution says no, I'll say no. But it's important to preserve this connection between law and words, and the specific no's in the Constitution give judges their firmest mandate. The Constitution is like a scolding parent. It wags a finger at government when it says, do not do this, do not do that. But what I'm saying is, it's a big, big leap from enforcing enumerated rights in the First, Fourth, Fifth, Sixth Amendment, and having judicially created breaks upon Congress's enumerated powers. That's a big step. Now, people ask me, they say, well, would you recognize any judicially enforced limits to Congress's enumerated powers? What would you do? Would you recognize any limits to the commerce power? Well, I have. I voted against I voted to invalidate on Commerce Clause grounds the Violence Against Women Act because it was created a civil right of action right at the heart of the state's traditional powers over domestic relations. Right. All right. But then they say, yeah, but you're not getting at the problem. And then they bring up what I call, and I'm glad we had it for lunch today, but I call it the Broccoli Hypothetical. All right, the Broccoli Hypothetical runs something like this. Suppose Congress told you that you couldn't eat broccoli, or that you had to eat broccoli. Would you would you strike that down? Well, you know, I have broccoli twice a week. Sometimes I have it with hollandaise sauce. Sometimes I have it with butter. I've never been told I had to eat the broccoli. I've never been told I couldn't eat the broccoli. So forgive me if I'm not losing, just please forgive me if I'm not losing a whole lot of sleep over the broccoli hypothetical. It doesn't strike me as within the realm of the possible. But what I do worry about is the fact that for 2 centuries, for example, Congress has tried the courts have tried without success to try to formulate some limits upon the enumerated commerce power. First, they said, well, the commerce power extends to commerce but not to manufacturing, and that was discarded. Then it was said that the commerce power extended to direct regulation. They drew a distinction between direct regulation of commerce and indirect regulation of commerce. Then in Lopez, the question was whether an activity in the aggregate had a substantial effect upon interstate commerce. Well, all of these tests were very fuzzy. They were very elastic, and they conceivably leave, if they get going, a great deal in the eye of the judicial beholder. And you can take phrases like that and put them to the point where you are, in essence, recreating a council of judicial revision that the framers eschewed. I guess part of my concern about judicial restraint is that I've lived in situations where people tried to practice a virulent form of activism, and the activism can be very contagious. It's like an epidemic. It can spread. When I clerked for Justice Lewis Powell on the court, the new thing was for judges to go in and to create constitutional entitlements to, among other things, an adequate income, a constitutional right to public housing, a constitutional right to public assistance, a constitutional right to a quality education. All of these things in the abstract were very appealing, but as a practical matter, they were disasters. They would have put judges in the driver's seat in a big way and had them the arbiter of the adequacy of legislative appropriations at both the state and the federal level. This is not, it's a danger when the habit of judicial activism gets rolling. And those who wanted to create constitutional entitlements to this and that and the other, they missed doing so by very slim margins, 1 or 2 votes. So I've seen how this can get going. I've seen people when they start to practice it. And it's a steamroller. And what they are going to do is they're going to displace popular sovereignty, and the feeling of participation that people get when they can determine their own destiny and when millions of Americans are not disenfranchised by a 5-4 decision of the United States Supreme Court. And it's important to give people a stake in the future of their communities and in the future of this society. And popular sovereignty helps do that in a way that judicial rulings on the most intimate questions of people's lives and the most important questions of people's lives and the questions in people's lives that they feel most passionately about. Let's give them the right to wrestle those things out in the political sphere. And let's not dictate to them how they should go, what they must think, and how they must live on the issues that matter most deeply and most passionately to them.
All right, so we're going to have a quick, just a 2-minute wrap-up by each of our combatants, 2 minutes or less. In the meantime, we do have, I think, 2 microphones set up here, and we're going to have until 2:15 for questions for any of you who have questions. So if you want to start moving to the microphones, and we'll get as many of you in as we can. So, Professor Barnett, if you want to wrap it up.
Right. Let me first express a note of agreement with one of the latter things that Jay just said, and that is I think that it is wrong to view the rights retained by the people as the kind of judicially created entitlements that many on the left have sought to pursue and achieve over the years, and I think that's what needs to be opposed. It needs to be opposed on that basis, on the grounds that that's not the kind of protection that we have against our legislatures. That's actually something that legislatures are responsible for providing. It's not something a court is responsible for providing, and we're more than capable of making that argument against the creation of those sorts of positive rights by judges, which I share with Jay concern about, without having to throw out the entire idea of the judicial check on the power of the legislature when it's doing something that it should not be doing. So that's a note of agreement I want to make. And I guess the last thing I will say is, Jay emphasized what he said is a list of no's that are in the Constitution, and there must be in the Constitution a list of no's. I mean, if I wanted to put in the Constitution some kind of way of rebutting what that position is, I probably wouldn't do it any better than James Madison did. I mean, there's only 2 rules of construction that are in the Constitution. One is in the 11th Amendment, came later, and the other is the 9th Amendment. It's a rule of construction. It's actually a rule to you that tells you, do not construe the Constitution the way you are. That the enumeration in the Constitution, that putting a list of no's in the Constitution, shall not be construed to deny or disparage the other liberties of the people that were not put in the list of no's. And so there actually is a rule of construction that says no to judges, and no to judges on this particular interpretation of the Constitution that they favor on political theory grounds. On the theory, they have a theory of democratic liberty, and they're pursuing that theory above the text of the Constitution. The last thing I will say in terms of the list of no's is, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That is a no. And in fact, but it is a no that that the federal courts have refused to follow since 1873. 5 years after its enactment, they rendered that no a nullity, and that's my objection. So I am only asking the courts to follow the text of the Constitution, all the Constitution, not just the parts that either meets a judge's particular standards of specificity or a political theory based on democratic liberty.
Judge Wilkinson?
All I can say is that with some of the things that my friend Randy would include in the list of no's, I have no idea what the criterion are. I have no idea what the criterion are.
I can help with that.
Well,
I can help. I want to help. I do.
You're an amicus, although an amicus means a friend. Now, I sit up there pondering Randy's list of no's. You know, they shouldn't abridge the privileges and immunities, and shouldn't engage in substantive due process and everything. I really have no idea what these things mean. I could read the 9th Amendment over and over and over again, and I couldn't tell you by what criterion I'm supposed to make a decision as a judge. And I think part of the reason that I worry, because even courts are falling in public esteem these days, is that the citizens of this country are wise in many ways, and they can sense when judges leave their warrant and when judges are stepping out of their prescribed role. And the more specific the constitutional provision, the better grounding we have and the more publicly persuasive it is. But if we start using provisions like privileges or immunities or the 9th Amendment, the The public is going to ask us, by what warrant? They're going to say, where did you get this? I would feel like I'm sitting there on the bench making it all up. And frankly, I feel a lot more comfortable interpreting ERISA or the Internal Revenue Code or the Code of Federal Regulations than I do interpreting the Ninth Amendment and interpreting privileges or immunities. I don't understand where they're beginning or where they end or what rights they encompass. All I know is that they're opening the floodgate, and everybody's going to bring their favorite right in. Some people like one set of rights, economic rights. Other people want personal liberty rights. And they're all going to just come flooding in under this big gateway that we've opened in terms of privileges and immunities or the Ninth Amendment or substantive due process. How substantive due process somehow strikes me as a bit of a contradiction in terms. I thought I learned the first year in law school that process dealt with procedure. But no, we're going to have substantive rights on those. And what are we going to do? It's going to be one big shopping bazaar when each set of judges goes and tries out and picks out what set of rights are its favorite. And the end of it all is you're going to have a judiciary with a large degree of control over people's lives, which people can't do anything about. And it's this thought of powerlessness that possesses people when you have a decision that they thought should be fought out in the natural and fair way in the ballot box, and it simply is decreed and imposed by a very limited subset of society and by one profession only from on high. Where are the plumbers? Where are the financial analysts? Where are the IT specialists? Where are the real estate brokers? Where are the teachers? Where are the firefighters? They're not on the bench. How would you like it if you got up in the morning and found out that another profession was calling all the shots for you? Well, maybe they feel that way about lawyers. There's a certain professional hubris at play here with judicial activism. You need to reflect on that. Look at how other people see you when one profession only is dictating for all others. Just a certain degree of modesty, folks.
All right, we'll move now to questions, and the only rule is that you have to ask a question, not make a speech, and tell us who you are and where you're from, and we'll move from there. Full disclosure: this is one of my law clerks, but
yes. So I hope my question does not displease the moderator, or else I'll have to. So I have a question for each of the panelists. Professor Barnett, I wonder if you might speak for a moment on about Leoptical. How do you derive a principle that would suggest that it is not a permissible policy choice for a majority in a republic to enact essentially a licensing regime to benefit this industry at the expense of that industry? It seems we do that all the time. I mean, even like we don't have to compete with paralegals, right, because of licensing. So thanks for that, big government. And for Judge Wilkinson, I wonder if you would, I think there's some ambiguity in your remarks. Would you go so far as to say there is no meaning that you ascribe to the words of the Privileges or Immunities Clause that would guide your judgments in a case, or just a very narrow construction? Thank you.
You want to go first, Jay?
Go ahead, Randy.
Okay. I think it's important, partly in response to this and partly in response to something Jay just said, to realize that I actually don't advocate judges identify rights and protect them after identifying them. That's the modern substantive due process doctrine, which I don't approve of. That's a post-New Deal device by which they got around some of the restrictions of footnote 4 of Caroline Products. I think basically the existence of the rights retained by the people is what justifies judges looking critically at the rationales that legislatures have for why they're doing what they're doing. And they ask them, what is the purpose for this? And then they have, in a sense, you might call it a theory, but at least a set of principles, which we used to have, about what the appropriate scope of the police power is. In the case of Leoptical, it was health and safety. It was ostensibly a health and safety law. That was what it ostensibly was. Health and safety is within the proper police power of the states. And as a health and safety law, they asked, what was the health and safety concerns that this law apparently addressed? And, they have one particular example there, which is of the lensometer, which is basically prohibited people, if you broke your lens and you wanted to go get a copy of that lens made, you could not go to an optician and get it made. You had to go back to an ophthalmologist and get it made by them, even though they might not even give you an eye exam and they might not give you a new prescription. You had to go back to them to get your new lens made. And basically they said, look, the way they do this is they put the lens into a machine called a lensometer, and it reads off the prescription, they make another one. And if you go to the ophthalmologist, he gives it to his lab assistant, and they go and put it in the lensometer, and they make another one. So there was just no reason for a doctor to be involved in that procedure. Now, there was no health and safety rationale for that restriction, but this just meant we knew why the law got passed. It was rational to pass the law because they wanted to help out their buddies, the ophthalmologists, who had political clout in the legislature. And this is the norm of legislation. We're in Washington, D.C. I don't know how many of you actually work here, but if you are here for any length of time or if you work in a state capitol, you know that's the business of legislators, is passing out these favors to their special interests that they have influence there. That's what they're in the business of doing. And we can't stop them from doing all that. The electoral process is a very important way of doing it. But look, people are not going to vote in Oklahoma on whether the opticians got screwed by this law. That's not going to ever be on any ballot.
Let's let Judge Wilkinson go ahead and answer
Okay.
these questions so we
Yes.
get some more participation.
Thanks, Judge.
Say, Jerry, I have a hearing problem, and the harder the question gets, the worse my problem becomes. So, can you repeat what this gentleman
Matthew,
asked?
why don't you just repeat your question, but
I'm
loudly.
going to ask you to repeat.
Yes. Judge, would you go so far as to say that you cannot discern any meaning that you would ascribe to the words which you describe as our master of the privileges or immunities clause, or that whatever meaning you would ascribe to it is just much more narrow than what Professor Barnett is suggesting?
Is there any meaning to the privileges and immunities clause that you would ascribe? Is there any meaning that the judiciary can give to the privileges and immunities clause?
Yeah, I mean, I know that there's great debate about it. There was at the time, but the 1871 decision in the slaughterhouse cases that Justice Miller wrote, I think was a great blow in favor of judicial restraint. It cabined the privileges and immunities, or privileges or immunities clause to certain national rights, such as a right to petition and a right to go on the high seas and whatever, and it left out a great many others. Now, the dissenters didn't like the privileges or immunities ruling of Justice Miller. It was a 5-4 case, and their problem was that it didn't recognize the right to earn a living, and so they wanted to import the right to earn a living into the privileges or immunities clause. Had they done that, it would have, I think, called into question all sorts of state legislation. And the federal judiciary would essentially be eradicating the federal system or impairing the federal system by telling state legislatures, what they could and couldn't enact in terms of occupational licensing, in terms of a minimum wage, in terms of this or that, in terms of qualifications for employment. The list is almost endless because everything can be seen in some way or fashion as a burden upon the right to earn a living. And what you would have had is the 14th Amendment serving as an enormous gateway, an enormous enlargement of federal power at the expense of the states. It would have eroded state authorities significantly, and would have put the judges in the driver's seat in terms of deciding what state legislation did and did not pass muster. And that was only one of the rights that was going to be imported in the privileges or immunities clause. That was just the beginning, and even the beginning was open-ended. So.
All right, let's move on to another question.
Hey, Ilya Soman, George Mason Law School. Can you hear me at the front?
Yes.
Great.
Full disclosure, another one of my former law clerks.
Yes,
I think we may have a hard time finding someone who.
Sorry, it wasn't planned this way.
It's a conspiracy.
I'm going to call on one of my former law clerks. They're here too. Maybe I'll get a friendly question from this audience.
So my question, however, is actually for Judge Wilkinson, and the question is this. Your concern about enforcing, say, the Ninth Amendment or the Privileged Immunities Clause is that these provisions are too broad and vague. But in your first book, From Brown to Bakke, which, by the way, I highly recommend, you defended the courts striking down of various laws that impose racial segregation, even though that was based on the Equal Protection Clause, which does not actually, on its terms, mention racial discrimination or any other kind of discrimination. It's very broad and vague. So in that area, it seemed like you would urge the courts to look at the history, the original meaning, and other evidence to determine what that vague phrase means and enforce it. So I was wondering why you cannot do the exact same thing with respect to privileged immunities or with respect to the Ninth Amendment or indeed other parts of the Constitution which speak in broad language just as the Equal Protection Clause does. Thank you.
That had to do with the use of the Equal Protection Clause.
Well, right, in that you spoke very, very vigorously in your first book about, particularly with racial segregation, about enforcing those provisions, and why would you not do the same with privileged immunities?
Well, I mean, that's a good question, and part of the reason is we fought a civil war over really the question of equality for Africans and African Americans, and that was the whole reason for the 14th Amendment, and that's the reason for the Equal Protection Clause. And I don't have the slightest hesitation in saying that one of the famous constitutional do-nots is you don't discriminate on the basis of race, and the most blatant kind of discrimination against on the basis of race was racial segregation, de jure racial segregation. And so I think that belongs in a category all by itself, but we did not fight a civil war over the right to earn an honest living. It doesn't mean the right to earn an honest living isn't a wonderful thing. It is a wonderful thing. But whether something's a wonderful thing or a terrible thing is not the same thing as whether it's a constitutional issue or whether it's a constitutional matter. And so the reason I wouldn't, I think it's quite possible to persuasively cabin the 14th Amendment into that very issue over which this country shed enormous blood and fought a civil war over, which was the basic equality of African Americans. And of course, the court had an obligation to enforce that right. But that doesn't mean that a lot of other rights simply piggyback on it and come in under the judicial umbrella ad infinitum.
And I just think it's really important to note that Judge Wilkinson, even before he was a judge, when he was a newspaper man, was one of the people in his community who was prepared to say no to race discrimination at a time when that was not a very easy thing to do. And I think he needs to, that's a person who said no when it mattered.
Hi, Judge Wilkinson. I'm Hans von Spakovsky, the Heritage Foundation. You place a great deal of...
Are you another one of Judge Smith's law firm?
No, I'm not. You place a great deal of emphasis on popular sovereignty and elections to check unconstitutional actions by the executive branch and the legislative branch. But doesn't that fail to take into account that we have something not contemplated by the framers, which is we really have a fourth branch today. We have a very powerful administrative state made up of federal agencies that don't respond to popular sovereignty, that they are populated 99% by permanent civil employees who don't respond to elections, and the only check on their power are judges.
Yeah, the question is you have the fourth branch of government, the administrative state, that's not popularly elected, and the courts are the only thing that can check them.
Yeah, and here I agree with you, and I think sometimes my whole view about being demonstrating deference to legislatures, I certainly would not carry that over wholesale to deference to administrative agencies, because in many instances, I'm a believer in Chevron 1, and that is where an administrative agency contradicts the explicit mandate of Congress and goes beyond its delegated authority, the courts absolutely should step in. And our whole commitment to popular sovereignty and legislative authority requires that we do so. So I find myself sympathetic to what you're saying. The advantage of administrative agencies, of course, is that they deal with very technical questions on a regular basis, and they have, we hope, a degree of expertise. The disadvantage of them is that they operate under the radar. Nobody knows most of the time what they're doing. They can become perfectly tyrannical, and they can go well beyond what the mandate of the statute gives them. So I think, you know, the agencies draw whatever authority they have from Congress, and a court's deference to the legislature would often mean drawing an administrative agency up short when it starts playing games with the congressional mandate and is off on some toot of its own.
All right.
Paul Kamenar. I'm not a law clerk, but I do know law clerks who did clerk for Judge Smith and Judge Wilkinson. If that counts.
There are a lot of them. Yeah.
Right. I would like to ask, I guess, Professor Barnett, particularly what he thinks about the political question doctrine. And what I'm thinking about, for example, is Goldwater versus Carter, where I argued myself on behalf of Senator Goldwater that the president did not have the unilateral authority to terminate the mutual defense treaty with Taiwan. The district court ruled in our favor on the merits. Court of Appeals, en banc, ruled against us on the merits with a couple dissents. Went to the Supreme Court, they granted cert. They vacated both decisions and said, in a plurality opinion, no one should have reached the merits. That's for the two branches to duke it out. Now, they said it was a political question doctrine, so I would not have mind either one of the courts on the merits being ruled, but how do you square that with the judge's duty to say what the Constitution is when it was a clear constitutional question?
Well, the first thing I just want to say about the political question doctrine is it's a made-up doctrine. I mean, it's a judicially created doctrine. It's not in the Constitution. And so for those people who don't like unenumerated things because they don't know what they are, there's another unenumerated thing for you. So the people that don't like unenumerated things believe in lots of unenumerated things. And that's just one of them. So but by the way, in my view, that's the fact that something's unenumerated doesn't mean it's wrong. It might be that the political question doctrine, though it be unenumerated, makes perfectly good sense. It particularly makes good sense when the Constitution does expressly defer to the discretion of individual branches, which it does in numerous places. I can't quote you, I haven't memorized those places the way I've memorized the Ninth Amendment, but there are numerous places in the Constitution, Nick probably knows where all those places are, where the Constitution specifically says it grants discretion to individual branches that says it may, or it is in its judgment, or in its discretion. All of those issues where the Constitution has expressly delegated discretion to one branch of government or another means they have that discretion to do it, and it's in their discretion. Whether there should be a global political question doctrine, I'm very skeptical of. So I think this has to be, whether such a doctrine in general ought to ever be applied in specific cases would really depend for me on the specific case. I don't have a global answer to that question.
Okay, so we have what George Will would call a hard break at 2:15. So we're going to let each of our debaters make a brief statement in conclusion. Judge Wilkinson?
Well, I just want to say what a privilege it is for me to appear at a Federalist Society program, and how much I just respect and appreciate the wonderful work that the Federalist Society has done over the years. You're a great organization, and it's always a pleasure to be here. And I also want to repeat my esteem for Professor Barnett. He has taught me a lot about constitutional law, and even where we disagree, I can't begin to tell you how much respect for him. And Randy, I'd love to agree with you on these things, except then we'd both be wrong. One other.
You're saving that one up?
One other final comment. And I'm a bit of a sentimentalist, and I get a real lump in my throat when I sing "America the Beautiful," and I get a lump in my throat when I say the Pledge of Allegiance. I mean, I really do. I tear up at patriotic things. And I guess because I'm such a law nerd or whatever it is, but I get a lump in my throat when I read the Constitution. Isn't that weird? But I read that document and I feel the same way that I do when I'm reciting the pledge or singing America the Beautiful. I mean, I think the Constitution is just that wonderful, and it's a work of genius. And it gets me very sentimental. And here we are over 2 centuries after the founders of America crafted this beautiful document, and Randy and I are just having a wonderful debate at this great society about what the document means and the tensions embodied in it. And it's just my hope that perhaps I'm naive here, but 100 years from now, my hope is that the Federal Society is going to be robust and growing, and that two good adversaries, 2 friends who respect each other a great deal, will maybe in this, if not in this room, somewhere else, will be debating the meaning of the American Constitution before a future gathering of the Federalist Society. Because there's no greater testament to the genius of the Constitution that we've debated it, and we'll go on debating it for years upon years. Thank you so much.
30 seconds if you want it, but no matter.
Yeah. I just want to thank Jay again for the service that he did to his country when he stood up for racial equality at a time in this country when that was a difficult thing to do, as both a journalist and then as a judge and as a lawyer and a judge. And I just do. It was a matter of character and courage for you to do that. And it is a question of saying no. So I think the problem we have with the judiciary is not that they don't say no, that they say no too much, is that they don't say no enough. And there weren't enough judges at that point to step up and say no the way you did when you were in private life. And I think that's really what I'm saying. And the only other thing I'm saying, I just want to go back to the issue of popular sovereignty, that the people are the boss, that each and every person in this room is is a joint sovereign of the United States, each of whom has rights. And under our system, for better or for worse, it is Article III judges as well as state court judges who are responsible for protecting these rights when they become unreasonably or arbitrarily or discriminatorily restricted by people who are supposed to be our agents in a legislature. And that's really the basic message I have. Popular sovereignty creates a judicial duty to follow the Constitution, and I really do think it means understanding each and every part of the Constitution, including the parts that are vague, because our liberties are expansive and broad. Thank you.